right, let's move on now to our next story. Detained leader of the Indigenous People of Biafra, IPOB, Mazi Nnamdi Kanu, has demanded his freedom as he challenged the validity of the 15-count amended charge the federal government leveled against him. During a resumed hearing of the alleged terrorism offences against him, Justice Binta Nyako of the Federal High Court Abuja fixed April 8, 2022 for ruling on a preliminary objection filed by his legal team. Actually filed by his legal team, I beg your pardon, after his counsel, Mike Ozekome, and the prosecution counsel, Shuaibu Labaran, argued for and against the defendant's preliminary objection.
Kanu also told the court that he was going blind, saying that since his detention, he has not been allowed to use the reading glasses provided by his family. Let's bring in our constitutional lawyer, Barrister Sisi Chukwudi, as he joins us live from Okame. Thanks for joining us on the program, Barrister. We just read this story now, and we're hearing that his counsel, his lead counsel, Zekome, has pleaded with the court to acquit and dismiss the charges filed against Kanu. And his argument is that the charges are baseless. Do you agree with him? Barrister, if you're there, you might need to unmute your microphone.
What happened there? Yes.
Please go ahead. We can hear you.
My microphone. Can you hear me?
Loud and clear. Please go ahead.
Very well. Thank you very much. What I have to say in relation to what transpired yesterday at Honorable Court, Federal High Court, Abuja, it is his constitutional right to aver whether or not the content of the charge upon which he was brought to the Honorable Court was competent or not. And that is what we consider as a preliminary objection, which are objections raised before the trial to sit. Because if he fails to state these preliminary objections at this stage, and at the end of the day, the trials and the street upon which he was being charged were indeed incompetent, then the entire effort made by the federal government, that is the prosecuting authority, to prosecute him would have been nullity. So it is important for the Honorable Court to determine at this stage the competency or otherwise of those charges upon which he is being charged in order to save both the court and the time of the Honorable Court.
All right.
So what the council determined, what the council asked as a question or his prayers before the Honorable Court are in tandem with the rules of natural justice. Because one cannot be tried on an incompetent charge or charges which are at best a mere merry-go-round. So we are looking at the entire thing because there are fundamental elements upon which a charge must be before
All right, we seem to have connectivity issues with Chukwudi's network, but hopefully he will get back to us and we'll keep this conversation going. But okay, Chukwudi, let's also ask this now. I'm more peculiar about this next question, especially from me. Looking at the fact that Nnamdi Kanu made a request. Now, his request was to have his clothes changed to the popular Isiagu outfit, which apparently was declined by the DSS on the basis that it offends the standard operating procedures. Does an outfit violate any court rules? Let me ask.
That must be indeed a mismatch and a total misconception of that particular procedure. Yes, if an outfit depicts a particular violation, then the court or the authority may
I really want to get an answer to that question very, very briefly, especially from Barrister Chukwudi. Barrister Chukwudi, if you hear us and you're back, and yeah, it's good to have you back. So go ahead. My question, does an outfit actually, does it affect the procedure? Just tell us.
No, it does not on a general answer. However, in specific terms, there are areas and outfits which may not be allowed to an ordinary individual, such as uniform to a security service or a security agency or any other uniform designed for any other authority. But what he asked is an Isiago uniform, an Isiago outfit. which is a traditional attire for people from a particular sector, Igbos and the rest, and any other person can wear it without restriction. So what the
I really wish we could get
of that regular procedure.
All right, Barry.
In essence, can you hear me?
Yes, go ahead now. Go ahead.
Yes, what we are saying is that the answer given by the DSS or their defense is misplaced and misconceived, because the outfit upon which he requested does not in any way offend any regulation in Nigeria. There is no law within this country that says that a person cannot adore Isiago attire. But there is a law saying that if you are not a police officer, you cannot wear a police officer's uniform. You cannot wear a military uniform if you are not a military officer. But what it says, I want to adore Isiago, it simply means that it's a general attire which any other person, including you, including an Alpha man, including a Yoruba man, can still.
And clearly, Barrister Chukwudi has told us that an outfit shouldn't affect legal proceedings, but in peculiar case like this, there's a reason DSS rejected or declined his offer. Barrister Chukwudi, I know you're still there now. The southeastern part of Nigeria is watching. I mean, the international community is watching. We also understand that a seat at home has been ongoing for a while with the economic implication it has caused. But what is the mood in Oka over there as we speak? What's the perception as all of this is unfolding?
It's just as usual. Like yesterday, there was a little or a fewer movement of vehicular movement and open businesses in the environment, just as it was declared to commiserate on the days of Nnamdi Kanu visiting court. The economic situation has indeed been affected by that particular declaration. Like no businesses were ongoing yesterday, no shops were open, no markets were open. In essence, what it entails is that nobody went about on their business areas just because of that court proceedings in Anambra State and other parts of the southeast. So what we are saying is that it's affecting the economic growth of the southeast. It's affecting the economic growth of every other individual who may have little or nothing, because some people are depending on their daily movement, daily opening of their shops, daily opening of their business areas. And by virtue of the fact that they could not open yesterday, they may have been affected. The same also applies to revenue accumulation by the government of that particular southeast. It does not in any way affect the people who are in court. I've said this time without number that the court happens in Abuja. And in Abuja, everybody has its means of movement, and there is no restriction whatsoever to the people of that particular region, any other region. In a sympathetical analysis, people of Southeast make such declarations, and it is indeed being obeyed by the people of that particular area. However, it has affected the economic output. Clearly, it has affected the family. Yes.
Clearly, it has affected. A lot of people are still trying their best to ensure that they can find a means of livelihood, especially just as you've stated, for people whose daily income is dependent on their daily activities. But many thanks for joining us, yes. Barrister C.C. Chukwudi, on the program once again.